Well, you had talked about the minor beneficiaries and trust and how that worked out. Give us some more detail about that.
Yeah, so typically with minor beneficiaries, remember before we talked about how they really can't inherit and shouldn't inherit. If they inherit, you're going to do that in one of really two ways. You're either going to do that through a guardianship or through a trust. If you do it through a guardianship, what a guardianship is it's a formal legal lawsuit where someone is appointed by the court to serve as the guardian over those children. Now that could be a guardian of their person, who makes decisions about their person, or it could be a guardian of just their estate, which is over their financial affairs. So it's usually with minor beneficiaries, what we see is they just have a guardian of the estate,
right.
Someone to manage their financial affairs. The problem with guardianship is it is a formal legal process. It's a lawsuit that has to be litigated. Litigation always involves costs. It always involves fees. So typically for guardianship, you're not going to get out of there for less than $5,000. And so that $5,000 is gone. It's not to the benefit of the minor beneficiary. It's only to the benefit of the attorneys and judge of the process, right? So at all costs, I would avoid doing the guardianship. I would always give stuff to minor beneficiaries and trusts. So
right.
If you know that your client has minor children or grandchildren that they want to give it to, you want to make sure that there's some kind of trust that provides for those children inside another trust or inside the will. Now there's a few different types of trusts that are available for minor beneficiaries. One of them is the Uniform Transfer Gift to Minors Act, and so that's really kind of a trust-based approach. So it appoints someone to act on behalf of as the trustee for the kid. There's also, you'll see in your textbook, a 2503B trust where it's a trust for minor beneficiaries where the income each year is distributed out to those beneficiaries. There's also a 2503C trust which accumulates the income instead of distributes the income. I mean, it has the ability to distribute income, but it doesn't necessarily have to distribute the income.
Right.
And so that's really the two distinctions. So the key thing to remember about minor beneficiaries is what you want to do is don't allow minor beneficiaries. Always for minor beneficiaries, provide for them some form of trust to hold their stuff. Don't let it be subject to a guardianship.
A huge red flag with clients when you're reviewing their beneficiaries. Make absolutely sure that there are no minor beneficiaries. Yes. Three basic methods for minors trust length.
Yeah.
Tell us about that.
So basically with minors trust, and this is really something that you do need to know because this is going to come up in your planning. People are going to ask, well, how can I do a trust for my minors? What would that look like, and when would they get their stuff? So there's basically three approaches that you can use. One is a trust that terminates at a specific age. So you could say, okay, well, I'm going to put the stuff for my kids into a trust, and it's going to last there until they turn age 25. And until they hit age 25, there's going to be a trustee in place, and that trustee is going to have a set of ground rules for what they spend money on and what they don't spend money on that are set out in the trust. The normal one is what we call the HEM standard, which means that it's a very general standard. It allows the trustee flexibility to pay for anything for the health, education, maintenance, or support of the child. And so it gives the trustee a lot of discretion. And when the child gets to this certain age, like age 25 in our example, then the trust will terminate, and whatever is left in the trust will be handed over to the child. So that might be a cashier's check.
Right.
It may be a deed to property, whatever. The second kind of basic trust that we usually do for kids is a lifetime trust. And so just like the name implies, it'll last for the entire lifetime of the child. And at the child's death, either the person who set up the trust will appoint who it goes to, or you may include a power of appointment and let the child say who the trust, the remainder of the trust goes to. During the kid's lifetime, that trustee is going to be in place, and they're going to apply whatever standard is in the trust for what they pay for and don't pay for. We use lifetime trusts a lot in situations where the child is actually a grown child and has is in a high liability profession, one where they're likely to get sued. Because remember, trusts are generally spendthrift trusts.
Right.
They're protected from creditors. Oftentimes we use lifetime trusts in situations where the child is not very responsible. So maybe they're 35 and can't balance a checkbook. Well, maybe you want the trustee to be in place for the child's lifetime. We also see lifetime trusts a lot when we hate the spouse. So I don't like the daughter-in-law, or I don't like the son-in-law, and so we want to, again, protect against what we think is the possibility of divorce or misuse of the funds. And so we'll have that lifetime trust in place. The third basic method for doing trust for children or minors is what's called a hybrid approach, or what I call the hybrid approach. And basically what you have is you have a trust that terminates at a specific age, like age 35, for example, but at increments, the child will get a oversized portion of their trust in cash. Mm-hmm. So like for my kids, the way that their trust is set up is for each one of them, until they reach age 35, the money will be in trust. But when each child hits age 25, they're going to get a third of the trust fund in cash at one time, a lump sum. And so whatever's in that trust at that point, they're going to get a third of when they hit 25. If they go to Vegas and they bet black and it hits red the very next day, it's okay because 2/3 of their trust is still in the hands of the trustee, right? So hopefully by the time they hit 30, they will have
learned the red
exactly
black
right.
lesson. Yeah.
And so when they hit 30, they're going to get half of what's left, which is effectively a third of the trust, second third of the trust. And then the same thing when they hit 35, the trust is going to terminate. Whatever's left goes to them. So from my vantage point, it's a way for me to sort of have in place a financial parent for the kid and kind of embed in the trust structure a learning component about how to handle money. And so, typically we'll see especially for minor kids, we'll see one of those three approaches. Either it terminates at a specific age, it'll terminate at the end of their life, or it will be a hybrid trust where they kind of get chunks of money.
Right.
And then it still terminates at a specific age.
So what other documents would we need besides the things that we've mentioned? What other documents are out there that we really should have?
So one of the things about estate planning is you really should look at estate planning as not just death planning. Mm-hmm. We've spent most of the time that we've been together talking about what happens when you die. What we haven't talked about is what happens if you become disabled or incapacitated. And that is part of estate planning. So when you're talking to your clients, you need to talk to them both about what happens if they die, but also what happens if they were to become disabled or incapacitated. And so besides the will or trust that they would need and the beneficiary designations they would need, what you want them to have is you want them to have a financial power of attorney, or what's called a statutory general durable power of attorney. But it's a financial power of attorney. You want them to have a medical power of attorney. You want them to have a HIPAA release. You want them to have a living will or advanced medical directive. You want them to have a guardianship designation for themselves. You want them to have a designation of guardian for any of their minor children, if they still have minor children. One of the things that people always ask me about is, well, don't I also need a do not resuscitate order? For your average client, for any client that is not terminally ill, do not have them sign a do not resuscitate order. And so that is not something that I would normally include inside of an estate and disability plan. So I don't know if you want to go over what each one of those things are, but those are the documents that you need.
All I'm going to say about that is this: some of these documents, obviously, you can get online. Okay, just like people can go get wills online. The only thing I will tell you is that from a personal experience, I had Chris a few years ago, actually many years ago, set up with my father's permission and him being there, obviously, set up my father's will. And of course, all these documents were included in that package. And I don't know, maybe 4 years ago, 5 years ago, something, my father had an incident where he ended up in the hospital. He had Alzheimer's at the time. So I went down there, and as hospitals do, they're very closed-mouthed about anything until I showed them. I'd taken the will out of the package, but I showed them the rest of these forms. They looked at it, and it was like the gates of heaven opened after that. Anything I needed or wanted was immediately taken care of from my father, and any demands I made were immediately handled. So all I can say is I'm sure you could probably go online and get a HIPAA release form, but certainly look at having those things included in the total estate plan if you've got an attorney, which you should have an attorney drawing those up for your clients, and have those all included in that. In your situation, you do it automatically anyway. I don't think it's some sort of discount or whatever. And so that way you know it's done right. All the I's are dotted, all the T's are crossed, and it's taken care of. And
if all you've done is plan for a client's death, you have done half of the job.
Right.
At best. And any attorney that's worth their salt when talking about this is going to make sure that you have every single one of those documents that we talked about, in addition to whatever they're doing from a trust and will perspective. And if they don't include that automatically, then that is not who I would send my client to.
That's a good sign of who not to send your clients to, exactly.